church.
Good afternoon.
God is good
All the time.
and all the time.
God is good and that is the nature.
Let's have our seats first. Thank you both for allowing me to be here this afternoon. And thank you, church, for being here to listen to me this afternoon. My name is Anne Amadi, as Provost had introduced me earlier. I'm an advocate by profession. I came here with my daughter, Maureen Latino. Maureen, just leave. Yeah. Thank you. And I'm here courtesy of our friend and colleague by the name Evelyn Opondo, who was supposed to be here today, but she was not able to come. So I happened to be in the county, so she requested me to come and speak to this congregation today. That's why I'm here. The provost spoke with me on, was it Wednesday? Wednesday or maybe Thursday. And because I wasn't sure what he wanted me to speak about. But he told me that the women have been celebrating something all week. And so I should speak about areas that may be of interest to the ladies, and I suppose the gentlemen as well, because they're here, because we live in one community, one society. Whatever I'm going to speak about covers all of us, men, women, girls and boys. I know that you're tired, you've been here since I don't know how many hours back. The provost had given me an hour to speak, but I will try to compress it, because I know your sugars are down now, and the sooner I finish, I think the happier you will be. So based on the discussions we had both with Evelyn and with the provost, I decided to speak on the areas of property. And this is property at the point of succession. How many ladies are married in the room? How many ladies hands up? Yeah, a good number. How many men are married in the room? Good. So I'm going to talk about matters property, both at the point of succession and at the point of, unfortunately, divorce. I know we frown upon divorce, we frown upon polygamy as a church, but the reality is that those things do happen because we're in a fallen world. I'll begin with the parts of succession. And I'll just share an experience that many years ago I worked with an organization called the Federation of Women Lawyers Kenya, FIDA. How many have heard about FIDA? Yeah? So I worked in FIDA, and therefore I have worked a lot with women who are in distress when it comes to matters property, matters family. And one thing I realized that all of my clients, except one or two, all of my clients, I saw a huge correlation between our economic levels and our exposure to violence, exposure to abuse, so that the poorer you are, the less educated you are, the more likely you are to be abused in life. The more empowered you are, the less likely you are to be abused by those around you, by your spouse, by your in-laws, by your brothers. And therefore, since Father was focusing on empowerment, I just wanted to raise that, to share that observation, so that we know that even as we sit here, it's very important for us to think about what our contribution is in society, because the more we are contributing socially, economically, the less likely we are to be abused. Starting with succession, I'll just give you one quote by a gentleman called Ralph Emerson, and this is what he said. He said that when it comes to dividing an estate, even the politest men will quarrel. Is that true? Yeah. And that is why you find that for a woman, you're married and you're living very well in your family, and the minute your husband drops dead, you will not recognize your brother-in-law. Is that true? There is that tendency to, turn against you, and everybody wants whatever it is that you want in the family, and nobody cares about the children that have been left behind. And many times, unfortunately, you don't even know what to do, because you've seen women's properties being taken, their whole household properties are carted away, the woman is left there crying, not knowing what to do. And unfortunately, it's not just uneducated men. I handled a case whereby a professor, no less, came and carried things from the sister-in-law's house with a truck, carried everything. And so when this lady came to see us at FIDA, we took up the matter, and he was supposed to bring the property back. You know what he did? He drove to the FIDA compound with the lorry and started throwing things down. Fridge, computers, cookers, many things of that nature being thrown from the truck. So of course there was a lot of damage. And we had the professor arrested. And he had to pay for all those things. And we were able to help the lady because she knew where to go. She knew that she could go somewhere and seek help. But unfortunately, many ladies will just sit there and cry and feel sorry for themselves and go back to their mother and try to deal with the situation whichever way they can. Many times they're not able at all to do anything. So it's really an honor for me to be here to just share some thoughts on the area of family law. And maybe just a word of caution, even as I speak, I'm not giving you legal advice, I'm just sharing information. But if you find yourself in a situation like this, it's always very advisable to look for the nearest lawyer that you can find. I don't know if there are any lawyers in the room. It's good to just look for a lawyer because there are no two cases that are identical. So that the information I'm giving today might apply differently to one person and differently to another person based on their unique circumstances. So if you find yourself umelemewa, usiseme Amadi alisema, you go and look for a lawyer and tell them your story so that they're able to apply it appropriately. We all know that in 2010 we got a new constitution, isn't it? And it says that we are equal, we are all equal, and a man and a wife are equal before marriage, during marriage, and after marriage. That is the principle that we're going to be predicating our discussion this morning. So the pain of losing a loved one is always compounded by disputes when it comes to division of property that is left behind. And worse still, where the deceased has not written a will. We don't like writing wills because we want to postpone our death. I don't want to write my will today because I have fear that I might die tomorrow if I write a will. How many have written wills in the room? No one. Please let's write our wills. So when there is no will, what happens? There are two types of succession processes. One is called testate succession. The other one is called intestate succession. So testate is where you have written a will, where your husband has written a will. And if I speak about your husband, let us use it the other way as well, where your wife has written a will. That is a testate succession. If you look at our law, you will notice that we started from a point whereby women were considered as not capable of having any property. But is that true? No. We have property, don't we? No. We are coming from a background where women were expected to stay at home, look after children, women were not expected to go to school, and so the law presupposes that only the man can have property, and therefore, even if you look at our succession law before the new constitution, it always talked about, it tended to presuppose that women cannot have property property which their husbands can inherit. But we know the reality is that in many families today, it is the women who are working even harder than our husbands. There are situations where both have contributed equally. There are situations where the man is contributing more. There are situations where the woman of the house is contributing more. So when you're writing a will, what is it that the law expects you to do? Number one, the law presupposes that you have capacity, that you are not mentally insane, that you're not writing things that you don't know. So number one, you have to be of sound mind. Number two, you have to be at least 18 and above. There are children who maybe have, they've been told that one is going to be yours, that will be yours, but you don't have capacity at that point to write a will until you're of majority age. And then you cannot be forced to write a will in a particular way. How many watched the video of this rich member of parliament, what was his name, Kirima, where you're locked up in the house by one wife and you're being forced to do things? Even if you wrote a will, before the law it would be an invalid will because you're not written it by your own free will, you've been coerced to write it in a particular way. So if the court sees that is satisfied that there was some element of coercion, then that will not be valid. And the importance of being of sound mind is that it is assumed that when you're of sound mind and you take a decision that is rational, so that you're not favoring one wife or one child at the expense of others, because you're not in a position to do what is rational. So the division is expected to be fair and carefully thought through. And that is why you find in some cases, even if you've written a will, the court can interfere with it if the court feels that you provided for some people more than others, or you left out people, completely. As you do your will, there's also a requirement that you need to have two witnesses there, so that I don't just, someone can create something and hold your signature and pretend that it came from the testator. So there has to be two people to witness, and the people who in the event of your death can confirm that indeed they saw you write the will, that they were there, that nobody forced you to do it, that you did it willingly. In some situations, you can also write in your will that should I die, then so and so is going to be the person to give effect to what I have said. So you choose the person who is going to be the administrator, the person who is going to make sure that everybody gets their share the way that you wanted it. Other than written wills, you can also give an oral will. You can say what you want orally if there are people listening. But the exceptions to the oral will are this. You see, sometimes you might get very sick and you think you're going to die. So you call your family or your trusted friend, your trusted brother, and you tell them, Katho, gari chaumi ngani, Katho mountain kamai. Does that happen? But if you recover and you don't die within 3 months, that will expire. Yeah? You must die within 3 months. So if you still want to live, maybe don't give an oral will. It might cost you to die within 3 months when you are supposed to have recovered. So if you give an oral will, and by God's grace you recover and you continue to live, and then you die after 1 year, somebody who was there cannot come back and say, now we don't have an watch, because it has expired. It cannot stand. Is that clear? Yeah, so it's that is how it is with oral wills. Now you can also revoke your will. The written will, you can always change it. Because sometimes you might write a will and then something happens. Maybe your child gets a grandchild and you want to provide for that child. You can change the will, you can revoke it and do a new one. But you cannot revoke a written will with an oral will. So somebody cannot come and say, yes, he wrote this will, but later on he said this. If you want to change it, it has to be written. You can also change your will. For example, if you get married, you've written a will today and then a year later you get married, then you have to again change it and provide for the new addition to the family. You can also, okay, just as an example, if you wrote a will and then you died just after marrying a new wife, as an example, clearly she wouldn't have been provided for in that way. So in that way then, the court can actually interfere with it to provide for the new person who had not yet been provided for. I know many times when there's an additional wife, the second wife, the third wife, and death happens, they have a lot of trouble for the first family. And it is something that the court can and actually has interfered with what is in the written document. Where a parent decides that maybe one of the dependents, one of the children may attack, or they are rude, they are a drunkard and they are not providing for them because they don't like their behavior, court can interfere with that and make sure that there's provision for that person. So who are the dependents? Who are the kind of people that you can provide for? We've seen in the Western world people providing for giving everything to a charity. And they say, if I die, all my money to go to Homa Bay ACK. And people respect it. But according to our law, dependents who are supposed to be provided for include a wife or wives, including former wives. If you're married and you left your wife and you got a new one, you have to provide for the former and the current, together with all their children, whether or not were being maintained by the deceased at the time of his death. It also includes the parents of the deceased. It includes the step-parents, it includes grandparents, grandchildren, stepchildren who the deceased had taken into the family as his own. It includes brothers, sisters, half-brothers, half-sisters, and that's where the problem happens. And that is why the law has prioritized who gets the first priority. Who gets the first priority. So the first priority usually will go to the wife and then the children, in the event that it's the one who has died. It is the wife who has the first priority, then the children. If they don't have a wife, they don't have children, then it goes to the parents, and it goes to the grandparents, and it keeps the priority order has been provided for very clearly, so that we minimize situations where someone has died, left a lot of property, but no successor. There is one important thing that the new constitution brought, and this is that there is no discrimination between women and men, girls and boys. So that when you're providing, many times the sisters will be told by their brothers, Vikachuri, something like that, and they even not want you to be there with, in case you had a child outside marriage and that child is at home, then the attitude is that, yeah, you know, dog food. But yet, as a daughter of that home, you actually have a right to inherit, so that whatever it is that is yours should go to your daughter or to your son. So So that is important to know, so that when you're being discriminated against on the basis that you had a child out of wedlock and you're at home, if you're being told to take the child to wherever you are able, you can put your foot down and make sure that your share can eventually go to child. The other thing that I would want to mention is that sometimes someone might die and they have debts. They have borrowed money from somebody and they haven't paid back. So that as a widow, then you cannot refuse to pay that debt. And when that your husband died before the debt was cleared, you're required to settle it. And if you don't settle it and the creditors go to court, they can actually the court can interfere with that with a will, so that the creditors can be provided for. What about situations where there is no will at all, written or oral? Where there is no will, what the law provides for is that the division depends on whether the man had one wife or multiple wives. So when he had one wife, you only get his personal things, and I don't know what those personal things household things. His personal things will be his clothes. I don't know what to do with those. And his shoes and his colognes and those are his personal things, maybe his car, household effects. And the other things, the real property, the houses, the bigger investments, you only have what is called a life interest, which means you cannot sell. You cannot sell unless your children give you permission to sell. So if your husband owns Cold Springs, for example, and he dies, you can use the things that are in the home, but you can use the rent from Cold Springs, but you cannot sell it, because that one you hold in trust for the children. Whatever else is supposed to be divided equally among the children. If they give you the consent to sell, and that is if they're 18 and above, then you sell and divide the proceeds equally to all the children. And once again, there is no distinction whether these children are boys or girls. They have equal shares. Now, there was one interesting provision that we had in the law of succession, which was that as a wife, the minute you remarry, then you lose that life interest. If you're taking the rent for Cold Springs, you stop taking it. If you were getting anything, you stop getting it because you are remarried. Yet, if I die now, the same doesn't apply to my husband. He can do anything with it. He can give it to his new wife. He can give my children. Yeah. So recently, actually last year, the court has decided that this provision is discriminatory, so that what applies to the woman applies to the man as well. If you can do anything with my property after I'm gone, I should also be able to do the same. There was also another discriminatory provision which said that if I have a child who has property, have another child who has property, and that child dies, then my husband has priority over that property to my exclusion. So that one also the court has recently said that it is discriminatory and therefore inapplicable. One thing you will notice about these issues of family law, the decisions of the court keep changing, and even for us lawyers, sometimes we get confused because you're following one principle, and then next month court will make a different pronouncement about the same issue. So it keeps changing, and always whenever there's a case, it's just good to find out what is the most recent pronouncement of the court. But this is the prevailing situation at the moment. In a polygamous home, it is a little more complicated because the property is shared among houses. And in the houses, a house is the woman, whether dead or alive, plus the children. So the wife and her children are the units of one house. So that if you have more children, then it gives you a bigger unit, a bigger share. However, it also depends on the circumstances. For example, if you've been married for 30 years and you've worked very hard with your husband and you've acquired property, and then your husband marries a 25-year-old, when it comes to distribution of matrimonial the property of the deceased, the court will consider that the first 30 years of marriage, this was contributed to by the first wife, and so then the division cannot be equal because the court will consider the fact that the labor of the first wife contributed to whatever was there, and they may only be able to benefit from what was acquired subsequently from the date that she got married. I don't know if that's a good thing or a bad thing. It's a good thing. The ladies my age will say it's a good thing. The 25-year-olds will say it's a bad thing because maybe it's the money they came for to begin with, and now you cannot have it. And that is to tell our young girls, like she's a beautiful young girls here, just stay away from those old men. Find a young person and grow with them. Senor. There are also other ways you can deal with property. This is maybe even for the men. You don't have to wait to die to deal with your property. You can decide to put your property in a trust where it's really yours, but then it's clear that the minute you go, this will go to whoever, this will go to whoever. So you can create a trust, and so you can decide that this is where I've put all my money. In the event that I go, so and so is going to be in charge of the trust. We'll make sure that all my beneficiaries draw their benefits from that trust. Usually you will indicate how you want it distributed. The best way to do it is to have it in equal shares. You can also give gifts in contemplation of death. You have a terminal illness and you know that you're not going to survive, you think you're not going to survive. So other than the 3 month rule I was telling you about earlier, you can give away your property. You can transfer to whoever you want the property to go to. And you can transfer the property to whoever and nobody can contest it. Any gifts that you've given when you're still alive cannot be contested. It is called a gift inter vivos, a gift that I'm given when I am still alive, and so it is yours, it is not subject to a succession process. Nobody can come to claim it. And even if you're contemplating death and you don't die, you can't say now give it back because you remember. Then you can also nominate. I know most of us are in circles, and in those circles, when you fill the form, you say, in case I die, I'm nominating so and so to have my shares. So that is another way of disposing of what you have. And you can also just have what is called a survivorship. A survivorship is where I decide that I am registering my property jointly with the provost here or with whoever, and should I die, then it becomes his. When you're two people registering a property, the other person dies automatically, it goes to the other person. So somebody cannot come to claim it and say, I want the share of the other person, because now it automatically moves to the joint owner. So much for succession. I know there are many questions, but I'll just talk briefly about division of matrimonial property. This is also another very problematic area because, again, as I said earlier, our context is such that women's contribution is usually minimized, and we know that the reality is different now. We have situations where the woman might be earning more, might be more hardworking, might be doing their, small businesses here and there and bringing in a lot. And so when it comes to the marriage breaking, we always pray for our marriages to survive, but that is not always the case. Sometimes it breaks down because the legal, the counseling, everything, and it can't work. So once the marriage is dissolved, what should happen? The law tells us that we are equal before marriage, during marriage, and at the dissolution of marriage. But what does this equality mean? If I'm married to a rich man, and I wake up in the morning, I have a maid, I have a gardener, I go to the salon, I go for massage, my car is fuels, and I'm good and life is good. And then suddenly this person dies. No, suddenly there's a divorce. Can I demand 50% on the basis of equality? Can I? No, you cannot. A lot of people have misinterpreted this law to mean that if the marriage breaks down, I get 50% and you get 50%. That is not the case. The situation is that you are equal to the extent of your contribution. Yeah? Are we happy or disappointed? Disappointed? You want 50%? Some of the things that the courts have said is that if I'm staying at home, remember the lady that I've described, yeah? The lady that I've described who is on a slave queen. Umekuja tu na urembo na, and your work is to be beautiful around the house. But there is somebody else who is in the house, making sure the house is organized, waking up early, preparing the kids to school, cooking for you, ironing your shirts, checking the shambas, making sure when the goats are sick, the vet is there, running around and cleaning her wall. Is there a difference between the first one and the second? Yes. Yeah. So in that case, that contribution is taken into account. Because you're even giving the man the peace of mind to go and look for the money. And you're working hard at home to make sure that he doesn't need to have other managers to do the work that you're doing. Because the work you're doing is not monetized. You don't get a salary for it, but it is very heavy work. So that is work that will be recognized, and it will be taken as part of your contribution. If you have bought property together, maybe you did not give the cash, but you're supervising the construction and making sure the workers are doing the right thing. You're making sure they've been given food, making sure the materials are not stored. All that is taken as contribution. But you may have also contributed to buying the iron sheets, and you are able to say, to build this, I had a little money I had saved, and I bought the iron sheets. So that will be, so you're being treated equally because kila mtu na mchango wake. So if any of us was under the illusion that 50-50 inakuja, be guided. So yes, just merely being married is not contribution. You have to bring something on the table. And then I think is that you might get married when you have something. You didn't just, so you're not just brought from your mother's house. You had also done some things. You had bought a house, you had bought a plot of land somewhere. You had some household effects. And your husband also had some things before you got married. Those are not matrimonial property. Those belong to the individual parties. Unless you eventually decide that you turn them into matrimonial property. Maybe you've done improvements together, and so it becomes kind of joint. But what he came with is not matrimonial property. So you can't start saying, the house you found him with, you want a share. It cannot work because it was separately acquired during marriage. You can also acquire property separately during marriage, and that will not be considered as matrimonial property. So to avoid some of these problems, there is a concept that we consider to be foreign, but I see a few young couples beginning to do that right now. And people are signing agreements before marriage. It's called a prenuptial agreement. When you're saying tukiwachana, itakuwa hivi. So you sign an agreement. We frown upon it because we especially as Christians, we say divorce is for life. What God has put together, let no man put asunder. So that then you're coming from the Christian mindset that if I write this agreement, I'm intending to divorce. And because of that, a lot of people don't do it. Some do it. And so if you sign that agreement, then upon dissolution of the marriage, you will go by that agreement. So basically, those are just small highlights of these two areas of property. It takes a whole year to study family law. So I'll try to wrap it up. Just small highlights, especially just focusing on what we observe every day happening. But what I would say is that family law, which covers succession and marriage and matrimonial properties, are very wide, complex area of law. So what I've done is just to attempt to share some of the very general rules. And as I said, should you find yourself in a situation of this nature, please find a lawyer. Don't go by what I say. At least you go there with some information. You will not be starting from a position of ignorance, and you'll be able to ask, but I had this. What do you say about this particular situations, the particular situation that I am facing? I'll just end by sharing a story. Something that happened many years ago. That was about 1992. How long ago is that? 32 years ago? And I still remember it to date. A violence situation, which was very sad, and it bugs me to date because I keep saying if I knew then what I know now, I probably would have dealt with it differently. I was a young magistrate in Kisumu, in a court called William. And I was serving in the children's court, which by that time was called the juvenile court. And a young lady was brought before me charged with neglecting her children. And the case was being prosecuted by the children's court, a children's officer. And I was curious because I was looking at her, she was fidgety and shy, and she was quite young. So they came and They gave the witnesses came and said, no, she came, she abandoned the children, she ran away, we don't know where she went, and the children have suffered, and therefore she needs to be found guilty with the neglect of children. So they finished the prosecution case, and it was this girl's turn to speak. And so this girl said this. She said she was in her home in Kano. Then her auntie came with her lady, and they said because her parents were poor and she was not able to go to school, her auntie came with some lady, and the auntie told her, this lady is going to take you to school. And her mother gave permission for her to go. She was taken somewhere in Seme. And when she got to Seme, she realized she had been brought to be the wife of a cripple who couldn't move, couldn't do anything. She was like 13 years old. So she's been married to this cripple, paralyzed from waist down, and it was actually a polio case, I think. And so all the men in that home were raping her. And she got 4 children from that situation. And because she was young, she had no money, she had nothing. The day she got an opportunity to escape, after saving and hiding the money in holes and everywhere she could, she took off and disappeared. And so now she's being brought to the charge with neglect of children. And I was listening to her and getting so angry. As a magistrate, you're not allowed to show your emotion. You're supposed to just listen and be objective, and you can show your emotions in your chambers later where there is no one. So when she spoke, and the final word she said is that if it is those children that will make me go back to that home, I'd rather die in jail. That is how she summarized it. Why am I sharing this? I'm just sharing this to show the extent of abuse that exists against women, especially when you're poor, especially when you're, economically disempowered. So that for the mothers who are here, I know we are all working hard, we're all trying our best for our children. And just trying to make sure that God will protect them so that they don't find themselves in a situation like that. But we live in a world that is cruel, a world that, we are not anyone's keeper. And I was listening to my sister there when she was speaking about unity. I think when we're unified, you're able to look out for each other. You're able to look out for each other. You don't know when you're going to fall dead, and you don't know what will happen to your child and unity once there. So let's be together, let's look out for each other. Let's keep learning and empowering each other. And Provost, thank you so much for letting me have this opportunity. God bless you all.
You say no to domestic violence. Thank you very much.